We begin tonight with breaking news. We have obtained what is expected to be a central piece of the government's case against Donald Trump. The actual audio recording of the former president talking as if he's showing a highly classified document on U.S. war plans against Iran with people not cleared to even know it exists, let alone what's in it. In a moment, only on CNN, you will hear what jurors will hear one day. The recording was made 2 summers ago, July 2021, at the former president's club in Bedminster, New Jersey. You will clearly hear the former president as he is speaking to several people. According to the special counsel's indictment, they include a writer working on Mark Meadows' memoir, the publisher, and 2 of Trump's staff members. The president was aware he was being recorded. This is the first time.
Okay, so the White House is in full panic mode right now. And I mean full-blown 5-alarm crisis. Because what just happened in the legal war surrounding Jack Smith, the special counsel who spent years building cases against Donald Trump, has completely rewritten the playbook for what happens next. The federal judge is now sitting on a ticking clock, forced by the 11th Circuit Court of Appeals to make a decision about devastating evidence that Trump and his allies have been fighting to keep buried for almost an entire year. And here's the thing. The deadline falls on January 2nd, 2026, which means that in a matter of weeks, the dam could break on Volume 2 of Jack Smith's final report, the one that details everything investigators found about Trump's handling of classified documents at Mar-a-Lago. We're talking about the full account of how a former president allegedly stashed America's most sensitive national security secrets in a bathroom, a ballroom, and a storage closet at his Florida golf club. We're talking about the obstruction, the defiance of subpoenas, alleged lies to federal investigators. And right now, all of that is frozen, locked behind a judicial order from Judge Eileen Cannon, the Trump-appointed jurist who has been repeatedly reversed by higher courts for rulings that favored the former president. But here's where it gets massive. Jack Smith himself was just subpoenaed to testify before the House Judiciary Committee on December 17, 2025. The man who built these cases, who faced down the most powerful political machine in America, who gathered evidence that he says would have led to Trump's conviction. Now scheduled to walk into a closed-door deposition where Republicans plan to grill him about everything. Democrats are screaming that the whole thing is a setup. Republicans are hiding Smith's testimony from the public so they can cherry-pick and distort whatever he says. Meanwhile, the Trump Justice Department under Attorney General Pam Bondi is actively blocking the release of the very report that Smith wrote, even as they're authorizing him to testify about it. Think about that for a second. They're letting Smith talk about an investigation while refusing to let anyone see the conclusions he drew. That's not transparency. That's a controlled demolition of the historical record. And if you think any of this is normal, you think this is how justice is supposed to work in America, then you haven't been paying attention to what's been happening in plain sight. Now look, we know that you can't really trust mainstream media anymore to give you the full picture on stories like this. They'll give you the headline, maybe a paragraph or 2, and then move on to whatever the algorithm tells them will get more clicks. That's why we built this channel, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, make sure you subscribe to the channel right now. Bring the news straight to you every single day. Just hit the subscribe button below to join us. If you want to support this work and be part of a community that truly cares about the truth, this is your moment. Subscribe. All right. Let's get back to the video. Here's what happened. To understand why this moment is so explosive, you need to understand the timeline and the players involved. Special counsel Jack Smith was appointed by Attorney General Merrick Garland back in November 2022 to investigate 2 separate matters: Trump's alleged efforts to overturn the 2020 election and his retention of classified documents at Mar-a-Lago. After leaving office for nearly 2 years, Smith's team worked relentlessly, issuing hundreds of subpoenas, interviewing witnesses, gathering evidence, and ultimately securing indictments against Trump on charges that included willful retention of national defense information, obstruction, and conspiracy. In the classified documents case alone, Trump faced 40 federal counts. Prosecutors said he stored highly sensitive national security records in unsecured areas of his Florida resort, including a ballroom, a bathroom, a shower, an office space, his bedroom, and a storage room. That he showed classified materials to visitors on at least 2 occasions, telling one group that a document was highly confidential and secret, and adding that as president he could have declassified it, but now he couldn't. Speculation. That's from court filings. That's from evidence Smith's team gathered. But here's where the story takes a turn that would be almost unbelievable in any other era of American politics. July 2024, Judge Eileen Cannon, who was assigned to the case and who Trump himself appointed to the federal bench, dismissed the entire indictment. Her reasoning? She concluded that Smith's appointment as special counsel was unconstitutional, a ruling that flew in the face of 50 years of precedent governing how special counsels operate. Legal experts were stunned. The 11th Circuit Court of Appeals, the same court that had already reversed Cannon twice for decisions that went too far in favor of Trump, was expected to take up the appeal. But then came Trump's victory in the 2024 presidential election, and everything changed. Following long-standing Justice Department policy that prohibits prosecuting a sitting president, Smith moved to drop the charges against Trump. The appeal was abandoned. The case was effectively dead. That didn't mean the evidence went away. That didn't mean the investigation never happened. And that's where Volume 2 of Smith's final report comes in. Smith concluded his work in January 2025. He submitted a 2-volume report to Attorney General Garland. Volume 1 covered the January 6th election interference investigation. It was released publicly on January 14th, 2025, and it laid out in devastating detail how Smith's team concluded that the evidence was sufficient to obtain and sustain a conviction at trial against Trump. The court said Trump was at the center of an unprecedented criminal effort to overturn the legitimate results of the election. Volume 2, one covering the classified documents case, never saw the light of day. On January 21st, 2025, Judge Cannon issued an order blocking the Justice Department from releasing it. Her stated rationale was that public release could harm the fair trial rights of Trump's co-defendants, former Vala Walt Nauta and Mar-a-Lago property manager Carlos de Oliveira, if the case were ever revived. But here's the problem. The case against Nauta and de Oliveira was also eventually dropped. The Justice Department dismissed the charges in 2025. Stated justification for keeping the report sealed evaporated, and yet Cannon's order remained in place. For months, transparency groups like American Oversight and the Knight First Amendment Institute filed motions asking Cannon to lift her injunction. They argued that the report should be released under the Freedom of Information Act, that there was no legitimate reason to keep hiding findings of national significance from the public. Months, Cannon did nothing. She didn't hold hearings, just let the motions sit there, gathering dust while the clock ran out on any chance of accountability. That's when the 11th Circuit stepped in. On November 3rd, 2025, the Thread Judge panel issued a directive that called out Cannon's undue delay and gave her 60 days to resolve the pending. The judges held de mandamus petitions in abeyance to give Cannon time to act. Counting forward from that date, the deadline falls on or about January 2nd, 2026. If Cannon fails to rule by then, the appeals court could take matters into its own hands, essentially ordering the release of the report, taking further action to compel a decision. And here's where it gets even more complicated. Trump himself has now intervened. On December 2nd, 2025, his lawyers filed a motion asking Cannon for permission to participate in the litigation as amicus curiae, arguing that the report should remain sealed because releasing it would perpetuate Jack Smith's unlawful criminal investigations and proceedings. Think about what that means. The sitting president is using the courts to try to suppress findings about his own alleged criminal conduct. He's asking a judge he appointed to keep the American people from seeing what investigators found about how he handled some of the nation's most sensitive secrets. Gets worse. Because while all of this is happening, Republicans in Congress are pursuing their own parallel investigation into Jack Smith, and they've now escalated to the point of issuing a subpoena demanding he appear for closed-door testimony. On December 3rd, 2025, House Judiciary Committee Chairman Jim Jordan issued the subpoena, ordering Smith to appear on December 17th. Jordan said the committee believes Smith possesses information vital to its oversight of the special counsel's operations. Here's the twist. Smith had already offered to testify publicly. Weeks earlier, he told Congress he would voluntarily appear in an open hearing, under oath, in front of the cameras, so the American people could judge for themselves. Republicans rejected that offer. They demanded a closed-door deposition instead, where lawmakers can question witnesses for extended periods, but the public sees nothing. Smith's attorney, Pietkowski, said they were disappointed that offer was rejected and that American people will be denied the opportunity to hear directly from Jack on these topics. Ranking member Jamie Raskin, the Democrat from Maryland, called it a backroom interrogation designed to let Republicans spin, distort, and cherry-pick his remarks through press leaks. And here's the kicker. The Trump Justice Department, under Attorney General Pam Bondi, has authorized Smith to testify about his investigations. They're still refusing to release Volume 2 of his report. Judiciary Democrats have written to Bondi demanding she produce the report before Smith's deposition, pointing out that Congress cannot meaningfully examine a witness about an investigation whose conclusions they haven't been permitted to review. The contradiction is staggering. The DOJ is saying Smith can talk about what he found, but nobody gets to read the actual document that lays it all out. That's not oversight. That's kabuki, theater, center of it all. Judge Cannon sits on a bench in Florida, holding the fate of Volume 2 in her hands, with a deadline ticking down to January 2nd and a president who is doing everything in his power to make sure that evidence stays buried. But here's where this becomes a lot bigger than one report, or one judge, or even one president. Because the fight over Volume 2 is really a fight over the historical record itself, over whether the American people will ever get a complete accounting of what happened during one of the most consequential federal investigations in modern history. and happening against the backdrop of something even more explosive, revelation of Operation Arctic Frost. This is the FBI investigation that Republicans have been screaming about for months. The one they say proves that Jack Smith and the Biden Justice Department weaponized law enforcement against political opponents. The allegations are stunning. According to Senate Judiciary Committee Chairman Chuck Grassley, who has been leading oversight into the matter, Arctic Frost resulted in 197 subpoenas targeting more than 430 Republican individuals and entities. Grassley says Smith's team sought phone records for at least 9 Republican senators and 1 congressman, as the FBI obtained communications data, banking records, and emails from conservative organizations like Turning Point USA and the Republican Attorneys General Association. And he says all of it was done under non-disclosure orders that prevented the targets from knowing they were being investigated. Controversy centers on Judge James Boasberg, the judge of the U.S. District Court for the District of Columbia, who signed off on the subpoenas and gag orders that Smith's team used. Republican senators like Ted Cruz have called it worse than Watergate. Cruz says Boasberg signed an order prohibiting AT&T and Verizon from informing senators that their phone records had been supposedly because disclosure could lead to destruction of evidence or witness intimidation. But Republicans say that rationale was baseless, that there was no evidence to support the conclusion that sitting senators would tamper with a federal investigation. Attorney General Pam Bondi has called it a historic betrayal of public trust. On November 4th, 2025, articles of impeachment were filed against Boasberg by Texas Congressman Brandon Gill, accusing the judge of abuse of power for authorizing frivolous nondisclosure. Orders that shielded Smith's investigation from congressional scrutiny. The impeachment resolution has bicameral support, with Republican senators writing to D.C. Circuit Chief Judge Sri Srinivasan demanding that Boasberg be administratively suspended pending formal impeachment proceedings. Now, Democrats have pushed back hard against these characterizations. They point out that Arctic Frost was opened in 2022 to investigate the so-called false electors scheme and efforts to overturn the 2020 election, and that the FBI's investigation followed proper legal procedure. The subpoenas were lawful. The grand jury secrecy rules were properly applied. Investigation evidence that led to legitimate indictments. Smith himself has defended his work as untainted by politics, calling accusations of bias absolutely ludicrous. But the political reality is that Republicans now control Congress and the White House, and they are using every lever of power at their disposal to reframe the narrative. Jack Smith is walking into his deposition on December 17th facing a committee that has already declared him a fundamentally corrupt prosecutor, in the words of Senator Cruz, being asked to defend an investigation that the sitting president called a witch hunt and a hoax. Very evidence that could vindicate or condemn him. Volume 2 of his final report remains locked behind a court order from a judge Trump appointed. Okay, let's break down what this actually means. First, understand that the January 2nd, 2026 deadline is a constitutional crossroads. If Judge Cannon rules to lift her injunction, the Justice Department could begin preparing a redacted version of Volume 2 for public release. That would mean the American people would finally get to see what Smith's team found about Trump's handling of classified documents. The obstruction allegations, the alleged lies, all of it. It would become part of the permanent historical record, available for journalists, historians, voters to examine. But Cannon could also deny the motions from transparency groups, keeping the report sealed indefinitely. Does that, or if she simply runs out the clock and fails to rule by the deadline, the case goes back to the 11th Circuit. At that point, the appeals court could decide to compel release, or they could defer to Cannon, or the whole thing could get tied up in further litigation that drags on for months or even years. Every day that passes is another day the evidence stays buried. Another day the Trump administration can shape the narrative without the inconvenient truth of what investigators actually found. Second, understand that Jack Smith's December 17th deposition is a trap wrapped in a legal proceeding. Republicans chose a closed-door format specifically because it gives them maximum control over what gets released public. Public hearing, Smith could lay out his case directly to the American people, under oath, with cameras rolling. He could explain why he pursued the charges he did, what evidence he gathered, how he responded to claims of political bias. But in a closed-door deposition, the committee controls the transcript. They can selectively leak portions that serve their narrative while burying anything that undermines it. They can mischaracterize Smith's testimony in press releases and floor speeches without fear of contradiction. And Smith, bound by grand jury secrecy rules and court orders, may be limited in what he can say to defend himself. The DOJ has authorized him to provide unrestricted testimony, but that authorization doesn't lift the other legal constraints that govern what a prosecutor can disclose about an ongoing or recently concluded investigation. Democrats know this, which is why they're demanding the release of Volume 2 before the deposition. Without the reports, Smith is walking into an ambush. Third, understand that the Arctic Frost controversy is being weaponized to discredit everything Smith found by framing the investigation as a politically motivated witch hunt. Republicans are trying to poison the well before any of the evidence ever sees daylight. It doesn't matter what Volume 2 says. If the American public has already been conditioned to believe that Smith was a rogue prosecutor targeting innocent Republicans, it doesn't matter what Smith testifies to if every word he says is filtered through a partisan lens designed to make him look like a deep state operati. This is the strategy, and it's working. According to a Rasmussen poll, 67% of likely voters now consider Arctic frost a serious scandal. A majority support impeaching Judge Both. The narrative has shifted from what did Trump do with classified documents to what did the FBI do? Republicans. And that shift didn't happen by accident. The result of a coordinated campaign to delegitimize the investigation before its conclusions can be properly evaluated. Fourth, understand that Judge Canane's role in all of this cannot be overstated. He is the single most important figure in determining whether Volume 2 ever becomes public. Her track record raises serious questions about whether she can be trusted to make that decision impartially. This is a judge who has been reversed multiple times by the 11th Circuit for rulings that went too far in Trump's favor. This is a judge who dismissed an entire 40-count indictment on constitutional grounds that most legal experts consider dubious at best. This is a judge who Trump has publicly praised and who now has the power to decide whether the evidence against him stays hidden forever. The transparency groups pressing for release of the report have asked Cannon to recuse herself, arguing that her past rulings demonstrate bias. She has refused. And so the fate of Volume 2 rests in the hands of a jurist whose judicial conduct has been questioned by appeals courts and who's appointed by the very person whose alleged crimes the report documents. Fifth, understand that the implications extend far beyond Trump. What happens with Volume 2 will set precedents that shape how future special counsel investigations are handled, how transparent the Justice Department must be in politically sensitive cases, and whether a sitting president can use the courts to suppress findings about his own conduct. Kanan keeps the report sealed and the 11th Circuit defers to her judgment. It sends a message that a single district court judge can indefinitely block the release of information of national significance. It creates a roadmap for future presidents facing investigation. Get lucky with judicial assignment, find a sympathetic judge, and you can bury the evidence forever. That's not how accountability is supposed to work. That's not how democracy is supposed to function. And if we let it happen here, with investigation, these moments we're setting ourselves up for worse abuses in the future. Now here's where this starts to hit home in ways that go beyond Washington power games. Classified documents at the center of Volume 2 weren't just bureaucratic paperwork. According to prosecutors, they included some of the most sensitive national security secrets the United States possesses. We're talking about information that, if disclosed to foreign adversaries, could compromise intelligence sources, reveal military capabilities, and endanger American lives. The indictment alleged that Trump stored these materials in unsecured locations where staff, guests, and even foreign nationals could potentially access. Mar-a-Lago isn't a secured government facility. It's a private club where wealthy members pay dues for access. The idea that the nation's most closely guarded secrets were sitting in a bathroom or a ballroom at a golf resort should concern every American, regardless of political affiliation. And yet, because of the way this case has been handled, because of Judge Kanan's rulings and the DOJ's policy against prosecuting sitting presidents, there may never be a public accounting of the full extent of what happened. That brings us to the international dimension. America's allies have been watching this saga unfold with growing concern. The United States asks its partners to share intelligence, to coordinate on matters of national security, to trust that the information they provide will be protected. What happens when those partners see that a former president allegedly mishandled their secrets and faced no consequences? What happens when they see that the report documenting that mishandling is being suppressed by a judge that same president appointed? The message it sends is corrosive. It undermines the trust that forms the foundation of international intelligence cooperation. European officials, NATO partners, intelligence services from London to Tokyo to Canberra are all drawing conclusions about American reliability based on how we handle situations like this. And every day that Volume 2 stays sealed is another day. Those conclusions get darker. Let's talk about what happens next, because the next few weeks are going to be pivotal. Jack Smith's deposition is scheduled for December 17th. By the time he walks into that room, Democrats may or may not have succeeded in their push to get Volume 2 released beforehand. If the report is still sealed, Smith will be testifying about an investigation whose conclusions only he and a handful of others have seen. Republicans will ask pointed questions designed to make him look like a political operative. They'll demand to know why he subpoenaed senators' phone records, why he sought gag orders, why he pursued Trump so aggressively. Smith will have to answer him without being able to point to the document that lays out the full evidentiary basis for his decisions. Setup. And Smith knows it, but he's agreed to comply with the subpoena anyway, because the alternative, being held in contempt like Steve Bannon and Peter Navarro were when they defied the January 6th committee, is worse. The irony is thick. Republicans who screamed about those contempt prosecutions are now issuing subpoenas of their own and threatening the same consequences for non-compliance. Meanwhile, Judge Cannon's clock keeps ticking. January 2nd, 2026. will arrive whether she rules or not. If she rules to keep the report sealed, transparency groups will immediately appeal to the 11th Circuit. We'll be back where we started, waiting for another court to decide. Rules to release it. Trump's lawyers will almost certainly seek an emergency stay, trying to freeze the disclosure while they appeal. Either way, we're looking at more months of litigation, more delays, more opportunity for the evidence to stay buried while the political narrative hardens. And there's a third possibility, one that legal observers consider all too likely given Cannon's track record simply run out the clock, declining to rule until after the deadline, at which point the 11th Circuit would have to decide whether to intervene. That outcome would be consistent with her past behavior in this case, where she has repeatedly slow-walked proceedings in ways that benefited Trump. Also the question of what happens in Congress beyond the Smith deposition. Senate Judiciary Committee Chairman Chuck Grassley has been aggressive in pursuing oversight of Arctic frost, releasing documents, holding press conferences, demanding testimony from DOJ and FBI officials. He's framed the investigation as a vindication of his long-standing crusade against FBI misconduct, dating back decades. Republicans succeed in discrediting Smith and broader Justice Department apparatus that pursued Trump. They'll have ammunition to justify sweeping changes of the FBI and DOJ. Director Kash Patel, appointed by Trump after his election victory, has already made personnel changes, firing agents and officials tied to the Trump investigations if the narrative of a weaponized FBI becomes entrenched. We could see legislation aimed at restructuring or weakening the independence of federal law enforcement that has implications that extend far beyond this one case, affecting every American who relies on impartial law enforcement. Here's the bottom line. What we're watching right now is a collision between accountability and power, between transparency and political survival, between the rule of law and the reality that those who hold power often use it to shield themselves from consequences. Jack Smith spent years building cases against Donald Trump based on evidence that he says would have led to conviction. His first report, the one on January 6th, laid out a devastating indictment of presidential misconduct. His second report, the one on classified documents, remains locked away. His conclusions known only to a handful of people. Its release blocked by a judge appointed by the man it investigates. Republicans are using every tool at their disposal to discredit Smith, from closed-door depositions to impeachment of judges who signed off on his subpoena. Democrats are fighting back, demanding transparency, filing amicus briefs, accusing the Trump DOJ of covering up evidence of criminal wrongdoing. And in the middle of it all sits Judge Eileen Cannon with a deadline of January 2nd and a decision that will shape how history remembers this era. The stakes here aren't just about Trump. They're about whether the American system of accountability can function when the person being held accountable holds the highest office in the land. They're about whether evidence of presidential misconduct can be suppressed indefinitely through strategic judicial appointments and favorable rulings. They're about whether special counsel investigations have been used for 50 years to ensure that high-level wrongdoing doesn't go unexamined and survive in an era of partisan warfare and delay. Volume 2 never sees daylight. If Smith's testimony is twisted and cherry-picked by a hostile committee, if Judge Cannon runs out the clock and the 11th Circuit declines to intervene, then we're living in a country where presidents can commit acts that would send ordinary citizens to prison and face no accounting whatsoever. That's not the America most of us grew up believing in. That's not a system of laws. That's a system of power, where those who have it get to decide what the truth is and who gets to see it. Keep your eyes on this. Watch what happens on December 17th when Jack Smith walks into that deposition. Watch what Judge Cannon does as her deadline approaches. Watch how the 11th Circuit responds if she fails to act. Watch how the Trump administration handles requests for the report and whether Attorney General Bondi continues to stonewall Congress. This story is far from over. In fact, it's entering its most critical phase, the phase where we find out whether the institutions designed to hold power accountable can do their job, or whether they've been so captured by partisan interests that they no longer function at all. The evidence is frozen for now, but ice melts. What's underneath could reshape American politics for a generation. This is a defining moment, not just for Trump, not just for Jack Smith, but for the idea that in America, no one is above the law. We're about to find out if that idea still means anything, and whatever happens next, I want to be paying attention, because the decisions being made right now will echo through our democracy for years to come.